Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law. And this will be what we're commenting on today. You might call it flim-flam. You might call it a perfect scam. But what it really amounts to is economic slavery, no different in practice than the debtor's prisons of Charles Dickens' time. A few days ago, I ran a video I actually did several months back on zombie debt, the issue of debt collectors suing on stale debt. And then I recently saw this story out of Arizona.
And Muniz told me that she bought a computer back in 2011 and said she paid it off right away. So you can imagine her shock when a debt collector sued her for nearly $3,000 for that computer she doesn't even have anymore. She was ready for anything.
If you're prepared, you don't have to worry.
So what was it like when you got this?
This was different.
This being a lawsuit from one of the nation's largest debt collection agencies, Portfolio Recovery Associates.
There are dozens of companies just like this with all kinds of different names that essentially are debt buyers, and they all follow the same playbook.
Demanding $2,700 from a Dell computer account back in 2011, a debt PRA bought in 2023.
This came out of the blue because I had no idea what this was about. It's not my debt.
Anne said she did buy a Dell computer more than 13 years ago.
But I paid it off.
And this lawsuit had no information about where the rest of the debt came from.
And to the people in the debt collection industry, that's a feature, not a bug. The less information that they put in there, the less chance they have of getting bounced.
So I don't know if this has to do with fraud, credit fraud, or what.
And discovered she was not the first Anne Munoz sued for this very same debt.
They sent that notice to an Ann K. Munoz in Memphis, Missouri. I've never lived in Missouri, ever.
Last April, PRA filed a separate lawsuit in Missouri and then dropped it to file a new lawsuit against this Ann Munoz.
Again, sadly, this is a common tactic that they use.
In Vernon, Arizona.
This video reminded me that it isn't enough to educate people about debt collectors generally, that there are a few people out there, good people, who are apt to get caught up in what I believe is an organized scam. As you heard in that case, they bought this debt in 2023. This recovery place bought it in 2023. It was supposedly defaulted in 2011, and that would have been well outside the statute of limitations in most states. So you have to wonder why in the world they are now suing on it. But I digress. Most people don't have the money to pay a good lawyer to handle something like this. So today I'm going to talk about these folks and provide some basic information. There are a number of resources on the internet for dealing with this kind of thing, with what I call zombie debt, or what is sometimes called stale debt. The bottom line is, if you are a lawyer and you're suing on a debt that you know is barred by the statute of limitations, you are not operating in good faith, and the representations made in the pleading are fraudulent and could subject you to being disbarred. So it's really kind of an interesting thing for me to look at from the standpoint of what the heck are these lawyers doing? Let's start with the basics and go from there. Let's do a little bit of Civil Procedure 101, if you will. Let's say that Simon Legree is an unscrupulous sleaze whose business is buying debt. When credit card companies write off a debt as uncollectible, they usually sell it for pennies on the dollar to somebody like Simon's company we'll call Proactive Property Solutions. Now, Susie had a MasterCard in 2007. She stopped using it in 2009 when she exceeded the credit limit. And using a credit counseling service, she repaid 80% of the debt in just under a year, and the company agreed to accept that as payment in full. That was in 2010 due to a bookkeeping error at the MasterCard bank. The remaining 20% was marked as uncollectible and written off. But due to an error by an inept bank employee, that 20% debt, a sum of $800, has been collecting interest on their books since 2010, and that's why it was sold to Preferred Property Solutions in 2023. Now, in 2025, it amounts to $18,000 and change due to a 21% default interest rate. If you take $800 and put 15 years of interest on it at 21.5%, what you get is over $18,000. Now, the deal Susie signed in 2010 with the bank made clear that the bank would never try to collect on the debt if she paid her 80%, which she did. But the agreement is nowhere in the bank's files, so having sold the debt to PPS, PPS sues Susie in civil court for the debt. The debt was originally occurred in 2009. In order to sue Susie, PPS has to put a few things in the complaint or petition. One of those is the amount, and they never leave that out. The other are the facts from which a contract can be proved. For example, a document that shows her signature. They can attach that to the petition. They sometimes leave that part out. Then there are the relevant dates. If Susie stopped paying in 2023, well, the statute of limitations would not have run. But if she defaulted in 2010, well, the statute of limitations is 10 years in most jurisdictions, and it may be shorter in some others. So in 2023, the suit would have been time barred. And quite naturally, if it was time barred in 2022, well, it's time barred in 2025 as well. But naturally, they leave out the dates because they don't want the court to know what the dates are. They just plead it out, pay their filing fee, and sit back and wait. In at least 90% of these cases with old, stale debt, the person who is sued doesn't understand the process. Also, they've seen countless stories on the news or Facebook or Instagram or any of the other social media sites discussing the various scams targeting people who may not have a lot of resources. And this is something that is designed to use that particular advice given to her against her. The lawsuit identifies the creditor as PPS, a company Susie never dealt with. How would she know what she supposedly did? Susie, in most cases, just throws the lawsuit in the trash since she thinks it's a scam. Or in some cases, she writes a letter to PPS, which is ignored by PPS because it's in their best interest to ignore that letter. What Susie doesn't do, but should do, is file an answer and demand strict proof of that debt. But because she's clueless about the way this world works, she thinks no more about it, and the lawyers representing PPS, most with reasonably good firms, wait their 30 days. It can be as short as 20 days in some jurisdictions, but if you don't file an answer within 30 days in most places, you are in default. So they notice up a hearing to have their default judgment granted. But here's a funny thing. If you are in default, there is no requirement for the other side to send you a notice of that hearing. So you don't know that they are getting ready to take you up, in this case, for default judgment. So she doesn't get noticed. She doesn't show up. Instead, the firm shows up at the hearing with 22 other default cases, and they go through them one by one with the judge. It goes something like this. The lawyer says, "This is a contract between Susie Clueless and MasterCard for a revolving charge account. The defendant defaulted on the debt and owes $18,000. We're seeking a judgment of $18,000 on the debt and a 30% attorney's fee of $5,400 for a total of $23,400 with costs assessed against the defendant." Attached, they will have attached an affidavit from the creditor, and the creditor's affidavit says just what the lawyer said and nothing more. It is evidence, but is it sufficient evidence? Now, in a really good courthouse with a really good judge, this doesn't stand a chance of prevailing. A good judge will ask all the relevant questions. Where is there a contract here? Where is her signature on the document? When was this debt incurred? When was it defaulted? And when the lawyer says, well, it was defaulted in 2010, he says, did you say 2010? Yes. What are you thinking? If it was defaulted in 2010, it's barred by the statute of limitations. What law school did you go to? But here's the rub. Most states have stratified court systems. There are lower courts, for example, small claims court, where the limit is usually no more than $3,000. And there are associate level courts, or sometimes called magistrate courts or justice courts. And those courts have a limit of around $25,000. In some states, it might be as high as 50. And then for really big claims, you go up into the circuit court or the district court, something like that, superior court, and that's where those cases get tried. But these, because they're under $25,000, are going to go to that mid-level court, the one between small claims and the superior court. Well, in that situation, what you have is a judge on the bench who is probably not really going to ever be a Clarence Thomas of the world. The guy sitting behind the bench is likely a graduate from a law school from somewhere within the last 10 or 15 years. He's worked as a lawyer for a few years, and he knows someone or knew someone who could get him in to the judicial appointment system. And so after laboring in the law for 5 or 6 years, he gets this appointment as a judge at this intermediate court level. If he plays his cards right, he might get elevated to the circuit court in a few years, and if he's really lucky, maybe he'll go on to be an appellate court judge in a few years. And he could retire as a judge and get some decent benefits. But if the judge was interested in trying cases, he's not really in a good place because the workload in these courts is quite significant. And the truth of the matter is, he's really functioning more as a clerk, somebody to rubber stamp something, than he is as a judge. He probably does not have time to go through all 22 of these pleadings, looking for dates and checking to make sure that they are within the statute of limitations. And because the court system assumes that when you are sued, you will vigorously contest it if you don't owe the money, well, the judge doesn't really have a legal responsibility to do that. He doesn't have a legal responsibility to go through the pleadings. If, indeed, the pleadings are deficient and you don't challenge them, it's your fault. And so that creates a perfect storm, and one that is quite frequently used to the disadvantage of the defendant in these cases. So the lawyer presents a pre-written judgment for whatever the amount is. The judge signs it, marks the case closed, and sends it on to the file, hands him the judgment. If the lawyers on the other end are smart, what they'll do is they'll wait a year before they try to collect on the judgment. Because in most jurisdictions, if you don't challenge a default judgment within a year, it's now written into stone, but there are a few small exceptions, but they probably don't apply here. So a year later, they're going to garnish the bank accounts. Yeah, that's right. They're going to strip out all of the funds to a zero balance. Doesn't matter if you've written checks on that account. They're going to get there first and take everything in the bank account. They seize and impound cars, place liens on property. They screw up Susie's credit beyond redemption and generally make her life a living hell because she thought she was being scammed. And she was, but just not in the way that she thought. Most of the time, however, law firms are not smart about this, so instead they go immediately to collection and garnishment, and here's a situation where a lawyer is probably going to get involved. They generate these garnishments and they go after a person's income, they go after their bank accounts, they go after their personal property, and they work those garnishments every month or every 90 days, whatever the rule is in that jurisdiction, and they just milk that cow dry until she sees a lawyer who usually recommends bankruptcy. Yeah, the same bankruptcy she sought to avoid by going to that credit counseling service. Now, again, it's not their fault that the bank reneged on it. In bankruptcy, PPS gets $9,500 after Susie's personal belongings and her Toyota Corolla are sold at auction. None of Susie's other creditors get anything because they're not judgment creditors. Their judgment creditors are people who are protected from a discount by a court judgment. But unfortunately, the bankruptcy court can't add money to make up for the difference, so they get what they get and they don't pitch a fit. Now, you're probably thinking that if the debt was really worth $18,000, then PPS must have taken a huge loss. No one would pay $18,000 for a debt and collect $9,500 and think they'd won the deal. But PPS did not pay $18,000 for that debt. They paid $111. The debt was assigned to them with language that stated, among other things, that the assignor, in this case the bank, the person assigning them the right to sue on this, the assignor did not guarantee the validity of the debt. There might be defenses to the debt which the bank was not aware, and that the bank would do no more than give them a printout of the account at the time of closure. In other words, the bank wouldn't supply anybody to testify about the debt if the debtor called it into question. Well, that's just fine with PPS because they are not going to use this situation to get into a contested debt situation. They're going to come in and just collect the money. So PPS has made a huge windfall profit on a debt Susie never owed and likely did not know how to challenge. Fortunately, this is a made-up story, but as the Arizona story makes clear, you don't have to ever have a credit card to be subject to this scam. You just have to have a name like Smith or Jones or Williams or Patterson, that kind of thing. Because if you have a very common name, there are doubtless lots of other people with your first name, unless, of course, it's something like Ichabod. Lots of folks have names similar to yours. So let's talk about what you do to prevent this outcome. First, recognize that just because the bank writes off the debt doesn't mean they can't still collect it, or in this case, sell it to somebody who can. If you owe money and you can't pay it, get yourself to a consumer credit counseling service immediately. See a bankruptcy lawyer if you are so far underwater that you can't see the sun. You can remove all of the chaos of being in debt from your life. It's difficult, it's humbling, but you do have options rather than trying to deal with it this way. If you owed and paid off a debt, or if it's been more than 10 years since you defaulted on the debt, you're probably protected by the statute of limitations. But if you get served with a lawsuit and don't do anything, you're going to get hit with that debt. So let me make this crystal clear. Doing nothing is submitting to economic slavery. Do not do nothing. If you can't afford a lawyer, there's lots of legal aid societies and many law schools where you can go and get help with this situation. And if you can't find a lawyer to help you, then answer the complaint yourself. There are lots of tutorials out there on the internet about doing an answer. Basically, you use the same set of numbered paragraphs in the petition or complaint as a model, and you write this on every paragraph. Defendant has insufficient information as to the facts set forth in this paragraph, and hereby denies the facts set forth and demands strict proof of the same. Whatever defenses you have to the debt, you must assert them in your answer. And it's also good to put in any affirmative defenses that you have in this case. Affirmative defenses are ones where you bear the burden of proof. For example, if the debt is more than 10 years old and you can prove that, you can check your state law for the statute of limitations on a contract, then put a separate heading on there that says affirmative defenses and number the paragraphs. Your first number would be defendant has never done business with the plaintiff and has no relationship with the plaintiff, if in fact it is a third-party debt collector. Your next one might be defendant is not the person identified in the petition or complaint. Next, you might say plaintiff has not alleged sufficient facts from which a contract could be determined and as such fails to state a claim. And your next one might be while the defendant does not admit any of the plaintiff's allegations, if defendant incurred any indebtedness in this matter, it occurred outside the statute of limitations. Plaintiff has not asserted the date when the debt was allegedly defaulted in order to avoid the statute of limitations. There are lots of resources out there to assist you in answering the complaint or the petition filed against you, but you have to file something. After completing the answer, you drive to the courthouse, ask the clerk to file the answer, then you send a copy of it to the lawyers who sued you by mail, or if they allow it, by email. You'll also have to go to every hearing that they set in this matter, and you'll have to push back. In the situation where you owe the debt and it's within the statute of limitations, sometimes just pushing back, denying everything, and letting the lawyers know you're going to fight tooth and nail to prevent having to pay anything on this can sometimes produce a beneficial result. Then at some point you reach an amicable agreement with the other side and you pay the debt off and it's done. And then you ask the court to seal the file so it's not used against you in terms of credit. Now here's a little secret. Debt collectors are usually quite lazy lawyers. They are used to going into a courtroom with a stack of 15 to 20 lawsuits that have been filed, putting them down in front of the judge, having the judge sign the judgment, and go on to the next place. And then they turn those judgments over to their clerks in their office, and then they produce all of the garnishments and everything like that to try and collect. But what they are not used to doing is actually having to litigate a case. Debt collection lawyers are a little bit like muggers. Muggers are never looking for a fight. They're looking for a victim, which is why when they confront someone and that someone is armed, they turn tail and run. The person with a firearm usually doesn't even have to fire a shot. They just run. If you make it clear that to the lawyer on the other side, who has a contingent fee agreement with the creditor in most cases, that they're going to have to work, they're going to have to answer interrogatories, answer discovery, fight over whether or not they're going to give you the assignment document, which in most cases they would usually rather dismiss the lawsuit than give up, they will get reasonable, usually very quickly. Well, that's what I have for you today, and hopefully that will help you avoid being a victim. There are places you can go, No Low Press being one of them, and there are numerous resources out there with regard to stale debt and that sort of thing. There are even other lawyers here on YouTube who say pretty much the same thing that I've said here. The bottom line is just this: don't be a victim. Get a lawyer and fight back. There are ways out of this mess. Thanks for being here. If you have the opportunity today, do something nice for somebody. And then when you have, come on back, join me down here tomorrow. We'll talk about something else.
I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.